I've got a wacky hypothetical for you today. Let's assume that one of your employees intentionally contracts COVID 19. Let's say he or she has a friend who he or she knows has COVID 19, and the employee decides, you know what? I don't care. I want to get some time off from work. I want to get some paid time off from work. So I'm going to go hang out with this person with COVID 19, get it. Maybe I'll never get it again, and I'll, get some time off for it. Is this person eligible for leave under the Families First Coronavirus Response Act, the FMLA? Both? Let's walk through this, huh? So the Families First Coronavirus Response Act covers employers with fewer than 500 employees and employers in the public sector. So if this employee works for a large company with 1,000 employees, then no, he's not going to or she's not going to be able to get Families First Coronavirus Response Act leave. But if this employee works for a company with fewer than 500 employees, let's keep it in the private sector, then yeah, this person's going to be able to get up to 2 weeks of emergency paid sick leave for reason number 2, and that is someone who is dealing with COVID-19 or COVID-19 symptoms, plus he or she's going to be able to get leave while they're going to the doctor to get diagnosed. And you're going to have to provide this person with paid leave up to $511 per day or his or her rate of pay, whichever is lower, for 2 weeks. All right, so this person can get FFCRA leave even if they get it intentionally. Well, there's nothing in the FFCRA that carves out someone who's a moron, but they get the leave. So let's see, do they get FMLA too? Well, what are the requirements for an FMLA leave? First, the person has to be an eligible employee, and actually, let's take it even a step further back than that. The person has to work for an employer. If we're dealing in the private sector, it's got to be an employer that employs 50 or more employees in the current or preceding calendar year, 20 or more weeks in the current or preceding calendar year of 50 or more employees. So if that box is checked, we've got a covered employer, but let's see if we have an eligible employee. First box, they need to have worked for the company for at least 12 months. Second box you got to check is you got to have 1,250 hours of service up to the point when your FMLA leave begins. Third, you have to work at a location that has 50 or more employees within 75 miles. And I realize everyone's remote working right now, but it's going to be based on kind of where your base of operations is when you're not remote working, because this is hopefully temporary. So let's assume that the employee checks all of those boxes. The next question is COVID-19 a serious health condition? And, well, I guess that kind of depends, right? I mean, if the employee is asymptomatic, then the answer could be no, unless the employee is under continuing treatment by a healthcare provider. That is the trigger for a serious health condition, an illness, injury, impairment, or physical or mental condition that involves continuing treatment by a healthcare provider. And I think we can agree that COVID-19 is an illness. So if you're asymptomatic, it's a close call, but maybe signs point to yes. Certainly if the person is suffering from the respiratory issues, fever, sore throat, you name it, and they're under continuing care by the healthcare provider, then yeah, that person is, they have a serious health condition. Additionally, another option is if they're going through inpatient care in a hospital, hospice, or residential medical care facility. Hopefully that's, regardless of how stupid this person is, we don't wish that on them. We don't want them to have to stay in the hospital, but consider that as well. If there's an overnight stay in the hospital, then serious health condition criteria may be triggered. So what do? Well, for the FFCRA purposes, you're going to notify the person that they're eligible. All right. You're going to give the person the opportunity to request FFCRA leave. Now, they can, if they want to, take their own bank of paid time off first, can can't force that on them, but presumably they're going to take their FFCRA leave. You're going to document it. You're going to pay them their leave over the 2 weeks, and then you're going to give that information to the IRS and get your tax credit when the quarter is over. All right. Stinks, but at least you're not paying for it. With FMLA leave, okay, FMLA leave, you can at least run paid time off concurrently. So if the person is getting their paid leave under FFCRA, you can run that time concurrently with the FMLA leave. And then if the person has any time left over in the bank after the FFCRA leave exhausts and they're still on FMLA, if that's the case, they're probably going to be back after 2-ish weeks. But if there's any time left over, you could run PTO concurrently if that's in your handbook. Alternatively, the employee can elect to run paid time off concurrently with the FMLA leave after the FFCRA leave exhausts. I know this is a lot to comprehend, but this is a wacky hypothetical anyway. And then ultimately the person returns to work, and when that person returns to work, you've got to restore them in the position that they held immediately before the FMLA leave, or at least something that is practically identical. Otherwise, you run the risk of an FMLA retaliation claim. So, I hope I've answered this wacky hypothetical question to your satisfaction, and I hope it never, ever comes up in your workplace. If so, do better on the hiring end. Now, you may be thinking to yourself, could you fire this person, right? If this person used such poor judgment to intentionally contract COVID-19, could you fire them for their poor judgment? And in most states, I'm going to put aside states like Colorado and California that have off-duty conduct laws, but in other states with no off-duty conduct laws, could you terminate someone? Assume they're at will. Could you terminate someone for this stupidity? I think technically the answer is yes. I think the problem, though, you'll run into is the timing is going to be so suspicious if you terminate them right either before they take the leave, during the leave, or after they come back from leave, that you're going to bite off a retaliation claim under the Family and Medical Leave Act, or maybe some sort of retaliation claim under the FFCRA as well. So you may be between a bit of a rock and a hard place. Again, hire a little slower on the front end. And hopefully you never run into this issue. All right, I'm rambling. I hope you found this interesting. If you like it, this kind of stuff, hey, consider subscribing to the Employer Handbook YouTube channel. Click that like button, or the thumbs up button, comment down below. Hopefully you've never experienced anything like this. And have a great weekend. I'll talk to you on Monday. Bye.